Good morning, sir. Are you William Leroy Jones?
Well,
Mr. Jones, in cause number 25 DCCR 1627, you're charged with the state jail felony offense of theft with previous theft convictions from August 3rd of 2025. The indictment alleges you were previously convicted of theft June 1st of 2023 in two cases. After that was final, November 16th of 2023. And then after that, August 6th of 2024, and then two cases on August 15th of 2024. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment is between 6 months and up to 2 years in a state jail prison. Do you understand? And then in cause number 25 DCCR 1628, you're also charged with theft of property with previous convictions. Offense date in this case is from August 2nd of 2025. Those same prior convictions are applicable and listed. Same punishment range if you're found guilty. Do you understand?
yes, ma'am.
And cause number 25 DCCR 1629, also charged with theft of property with previous convictions from August 9th of 2025. Same prior offenses. Convictions are listed. Again, means if you go to trial and you're found guilty, the range of punishment is between 6 months and up to 2 years. Do you understand?
Yes, ma'am.
And then finally, in cause number 25 DCCR 1630, you're also charged with theft of property with previous convictions. This is from August 15th of 2025. Again, it lists the same prior convictions, makes it the same punishment range between 6 months and up to 2 years. Do you understand? Excuse me. In all of those cases, I have here on the tablet some documents called plea bargain rejections that you signed with Mr. Lewis. This shows that the district attorney's office has made offers if you wanted to enter pleas of guilty. And it looks like for 20 months in the state jail, and that would run concurrently in all the cases.
Yes, ma'am.
You have every right to reject that offer and have all four of your cases tried to a jury. I want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that?
Yes, ma'am, I do.
And do you want to reject those offers and have all of your cases set for trial?
Yes, ma'am, I do.
All right, we'll get that done. Ms. French, is there any reason to believe that that offer would be reduced?
Mr. Lewis has spoken with me this morning about a possible issue for me to consider. I don't know that that's going to move the needle for me, but it's a possibility.
So what I'll do then, I would like, is that, how long will it take you to kind of look at that? And I don't want to put it on the trial docket. If there's a potential, we could do it as soon as that's over. So let's reset it for 2 weeks.
2 weeks.
Okay.
If there's some change in offer, then I've already, if you want to, okay, just leave them there. I've sent them to you and we can always write on it if it changes to a different offer. Otherwise, we'll go through that process of setting it for trial on that day. All right, so we'll reset it for 2 weeks.
Thank
Thank
you.
you.
And I'll go speak with Mr. Child.
Okay, thank you. Good morning. Are you Donnie Smith?
Yes, ma'am.
And Ms. Holmes, will your client waive the formal reading of the indictment?
Hello, Your Honor.
Mr. Smith, in cause number 26, DCCR 0072, you're charged with a second-degree felony offense of assault on a peace officer from December 28th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any type of any right to appeal?
Yes, ma'am.
And so I see it's just marked off community supervision, but nothing
So
else.
we're unagreed as to the type. The state is recommending straight probation. We're recommending deferred.
And leaving the type and the amount of time
Yes.
up to the court. So I want to make sure you understand that the agreement is that you get a probation. The type of probation, whether it's straight or deferred, will be up to me at sentencing, and also the length of time that you're on probation and any conditions and any fine in addition to that. Do you understand?
Yes, ma'am.
And you have an absolute right to have a jury come in and determine if you're guilty or not, and you could leave your punishment up to that jury. If we go forward this way, you're waiving that right, and is that what you have to do?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number one.
No objection.
It's admitted. Is there any evidence that Mr. Smith is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty.
This is a huge moment in the courtroom. Donnie Smith has just pleaded guilty to assaulting a peace officer, a serious felony. By doing this, he's giving up his right to a jury trial and leaving his fate in the judge's hands. Now the big question becomes, will the judge lean toward probation, something much tougher at sentencing interview?
Guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Ms. Malfino, what is the state's position with regard to a bond reduction based on that plea?
Judge, in reviewing Mr. Coleman's notes in this case, it doesn't appear that this young defendant has any substantial criminal history, just so the court is aware of pending UCW and evading also arose out of this incident. And so it's obviously concerning to the state that a weapon was involved, but I've heard of what you think is appropriate, unless Mr. Coleman has additional to add.
Nothing to add to that. Thank you.
Thank you. All right, Mr. Smith, what I'm going to do based on the nature of your plea agreement is reduce your bond in your case to $2,000. If you make that bond, there's a couple of very important things that are going to go along with it. One, the very first thing you do is go straight to the probation department so they can start that process to get that report done for me. If you don't do that, then you run the risk of me not accepting the plea agreement. Things could be much worse. Do you understand?
Yes, ma'am.
Also, if you make that bond and you are arrested for anything between now and when you come back, you obviously run the risk of me not accepting the agreement. You understand that as well.
Yes, ma'am.
In addition, I'm going to order as a condition of that bond, you are to have absolutely no possession of any firearm. Okay.
Ma'am.
That means you can't be in a car with someone else that has a gun. You cannot be in a home where there are guns. You cannot be around any guns until further sentencing. We'll figure that out depending on what's going on with that misdemeanor case. Do
Yes,
you
ma'am.
understand? Any other conditions that?
No, Judge.
All right, then we will see you at sentencing. You can go back.
The
with
hearing
bailiff.
ends with Smith's bond reduced and a pre-sentence investigation ordered. That report will heavily influence the judge's final decision. One wrong move before sentencing could change everything. Do you think he deserves probation? Or should this case lead to jail time? Let me know in the comments.